Welcome, everyone, to another edition of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I'm Rich Lenkov. I am the CEO and founder of SERMA, and we're very privileged to have today one of our SERMA members. It is Michael Pang, founding partner at Allison, McLean out of Newport Beach, California. Michael, welcome to the podcast.
Thanks for having me, Rich.
So you and I both have defended sports teams against athletes alleging injuries sustained while employed by these different teams. And one issue that you always face, I know, is jurisdiction, right? Athletes are obviously, by their nature, they're traveling employees. They are frequently injured in a different place from maybe where they signed a contract or even from where their employer resides. So one of the baseline issues that you see in these claims, not as much maybe in some other claims, is jurisdiction. So you're going to talk today about, what some of those issues are and how you defend them. So sort of an overview of how this issue comes into play, from your perspective in California, Michael.
Well, as you know, California has rather generous work comp benefits, and the statute of limitations here is a little loosey-goosey in that we're required to give notice to the athletes about their work comp rights. If they don't get that notice, the clock doesn't start ticking. So naturally, you got a lot of athletes coming over here filing claims. Some guys might be 5, 10, even 20, 30, 40 years out. They're filing claims here. Actually, I've seen cases in the 70s, and I realize it's 2022. So we're talking about 50-year-old cases being filed in California because that clock just doesn't start ticking. So one tool for us is to try to shove the venue out, argue that California is not the proper venue. There's been some case law, and the legislature actually got involved in 2013, passing some laws that allowed us to do that. But of course, the attorneys always find the loopholes.
So, of course, when you're injured as just, let's say, a regular non-athlete employee, are you allowed to pick your state? Does that differ when you're an athlete? How do those two things correlate?
Well, the key thing for California is if you got hurt in the state of California, there's jurisdiction. And if you signed your contract for hire within the state of California, they can assert jurisdiction. So for most non-athletes, it's pretty straightforward. California employer, California employee, injury took place in California. The weird ones, as you might know, are the truck drivers, flight attendants, people who go state to state. So for regular people, it's not much of an issue. They either got hurt in California, there's clear California employment, there's a clear California connection. They get notice either in a handbook or in the actual notices from the work comp insurance companies, or even in the break room. The notices posted on the wall about the work comp rights, where to go if you get hurt, who to contact. So for ordinary people, it's not much of an issue. For the athletes, however, prior to 2013, it was pretty loosey-goosey in that if the athlete came and played one game in California, or even just practiced in California, they had a right to file a California work comp claim. Because in California, they allow for cumulative trauma injuries. You don't see this much in other states, but the idea is that wear and tear over the career causes damages to the various body parts. And with football, of course, there's the concussions issue, and that's become a big deal, as you know. So the wear and tear issue, cumulative trauma, these athletes were claiming, hey, played one game in California, or I practiced, or I had a scrimmage, and that contributed to the overall wear and tear. But 2013, some cases came down, legislature got involved, and they're asking for a bit more substance to that, rather than just the whole one game, one practice, one whatever.
What do you have to prove as an athlete to avail yourself of California jurisdiction?
So, as you know, minimum contacts, personal jurisdiction, you have to prove that the actual play in California contributed to that wear and tear. For the most part, that's pretty easy. I mean, you can get any doctor to say that, yeah, that game in California contributed. Others, it might be a little easier. They tripped and fell. it's on television, or you had 60,000 witnesses in the stands watching. So that's pretty easy. But for the most part, if they can show that the games played in California contribute to that, you have exposure there. And the courts, along with the legislature, they ask for more than just basic minimum contacts. For example, as part of the legal changes, they wanted to show that there was substantial contacts with California, at least 2 years, 20% of your duty days, or that's up for litigation, but 20% of your the games played, so whatnot, practices took place in California. So they want more than just that basic contact.
Now, I was really interested, being a football fan myself, Mike, in reading some of the background to this story about the Joe Montana rule. I thought the Joe Montana rule might have been that you get to pass the ball to the greatest receiver of all time, or maybe that you remain cool in the huddle during the Super Bowl. But it means something very different legally.
Yeah, so as I mentioned, the legislature in 2018 stepped in, something called AP 1309, and they imposed some limitations on the players from out of state filing claims. And one of the issues that came up was, hey, what about Joe Montana? Played for the 49ers for a long time and then ended up on Kansas City. Does he get precluded? Can he not file a claim even though he spent so much time in San Francisco, throwing to Jerry Rice over and over again and just demolishing my poor Raiders? But anyway, the legislature then came up with a compromise, the Joe Montana rule. So a player has to play at least 2 years within California and no more than 7 years out of state, and then they'll be able to file a claim in California.
So I know there's lots of case law that's on point, that's interesting, some names that any football fan will recognize. But what are some of the couple or three important cases, and how have those influenced handling these cases from a jurisdictional perspective since 2013?
Well, the key tool back in 2013, like I mentioned, there's some case law that came down, the venue clauses within the contracts. So one big name was Bruce Matthews. He filed a work comp claim here in California, and the contract had a change venue clause. You can't file in California, you should be filing the claims in Tennessee. So they went to federal litigation on that, and an arbitrator actually came down and ruled that those venue clauses are enforceable. So quite a few players were barred from filing claims in California. A number of cases were allowed to proceed. Guys who played in California at one point in their career, or maybe they're from California, they signed their contract in California, triggering what we call Labor Code Section 5305, contract for hire in California. So those guys were allowed to proceed based on the facts. But those players who were from out of state, they were barred. And the California state courts actually also enforced that. There was a case called McKinley, who was a player for the Arizona Cardinals. And in the Cardinals contract, it explicitly stated work comp claims must be handled in Arizona, not California. And so that was enforced also. But again, it's very fact specific. You got to go case by case. The players and the teams have quite a burden on both sides to proceed. And the courts are not willing to dismiss cases right off the bat. So there's a lot of discovery involved with these matters.
So if some of our listeners are defending claims by athletes, football or otherwise, and they are suspicious that there might be a viable jurisdiction defense, what's kind of the first couple things they should be doing when they receive a claim?
First thing to do, go through the records. You need the personnel records. You need the medical records. You need the game logs. You need to see when they were in California, if at all. As you know, sometimes, like baseball, there might be phantom transactions. People assigned to a minor league affiliate, they never actually reported there. They're just trying to balance off the rosters. So on paper, it looks like they reported to, say, Lake Elsinore or Stockton, California. But in reality, they were never there. So you absolutely need the records. I harp on this all the time, I know. The teams are probably sick of it from hearing from me. First thing I always ask, hey, records, I need the contracts. I need to know where the contracts are signed. Were they signed in California, or were they signed in the training camps or in spring training in Arizona or Florida for baseball? I mean, that's just really important. And honestly, these days, I don't know if there's really an excuse not to have the records. Most people, I think, are scanning them in starting, 08, 09, 2010? So the newer stuff, we can get the records pretty easily. The older cases, like those I mentioned 20, 30, 50 years ago, those might be lost or sitting in some warehouse somewhere. So for us as attorneys, we turn into investigators. You're going through the old game logs. You're going through old newspaper clippings to find the game logs from some obscure small-town newspaper. Did the guy actually play in the game? Or was he just dressed and sitting on the sidelines or sitting in the clubhouse the entire time? There's a lot of work involved, unfortunately, at the onset of a case.
Michael, it sounds like a lot of the work that you do on this particular issue in defending jurisdiction sort of bleeds also into defending these claims on a causation, from a causation perspective. Because when I defend these athlete claims, we're not spending that much time on jurisdiction. We are spending a lot of time on causation, right? Because the key obstacle that any claimant who played professional sports has is causation. These are typically athletes who have played their entire lives, right? And they generally only have played a short period of time in the pros for whoever, the respondent is, whoever the employer is. They probably employed, if it's typical, and the typical age life for an NFL player is very short, they typically employ the person for a very short period. So what we're finding success in defending frequently is causation. And it's along the same lines of what you said. If it's difficult to prove jurisdiction from just simply by playing in that state, that same logic applies to causation. It's got to be difficult to prove that your short period of employment with the 49ers or the Rams or whatever team you're defending, that's what caused your current condition versus the years you played football before that, right? How are you going to prove that a concussion was the result of your time with a team in California versus the years you played up until that point? And then maybe
Absolutely.
After you left the employ of your team in California. So along the same lines, our listeners and viewers should keep in mind that causation is very difficult. It's petitioner's burden to prove, and like jurisdiction, it's not maybe as easy as you think it is to prove.
Absolutely, and that's where I harp on the medical records.
Right, exactly.
Work comp, you break it, you bought it. But if you didn't break it, it shouldn't be your problem. So in California, for indemnity benefits, you're not responsible for what you didn't cause. But unfortunately, future medical care, and that's where most of the exposure is, if you're 1% liable, then you can't apportion future medical care. That's pretty much the rule in California. So some of these guys, let's say they've played 3 years in the NFL, but they grew up playing flag football, Pee Wee League. They played in high school, college, so 4 years high school, 4 years college, and then 3 years in the NFL. You see the wear and tear. And the doctors will say, okay, maybe it's 50-50, maybe it's 25-75. The indemnity benefits are protected in California. You got that apportionment, that's what we call it. But the future medical care, you cannot apportion future medical care. So if you're seeing some of these guys, after all these years of playing football, they need surgeries, scopes of the knees, shoulders, the teams might be liable for that. So honestly, the future medical costs are what scare me more than the indemnity benefits.
Yeah, and this, again, the defense of a claim based on jurisdiction really frequently comes down to looking at the contract. So one of the dilemmas anytime you're dealing with a professional athlete claim is that the union behind them is pretty strong. I mean, most of these leagues have pretty strong player unions. But let's say that you were being hired by a brand new startup league, right, with not a strong union, and you were advising them on how to negotiate this particular issue, that of jurisdiction. What would be the most advantageous yet acceptable by the other side means of dealing with that in this brand new hypothetical, paying professional sports league?
So there's two types of sports cases we have to look out for. There's the cases where the guy's playing for the team, gets hurt with the team, and they're being treated medically by the team. Those, for the most part, aren't a concern. The teams, it's in their best interest to get these guys back on the field as soon as possible. So they're going to provide the necessary treatment. They're under contract, so they're getting paid, so that's not an issue. So for a new startup league, maybe they can come up with an ADR process, alternative dispute resolution, where they can come to a mediation and fast track the benefits even more. I mean, work comp is meant to be a fast track of benefits and medical treatment. If you come up with the ADR process, you can slim that down and narrow it down even more. The danger, though, are these cases filed after the guy's been released by the team, or is a free agent, or his career's ended, has hung up his spikes, or she's hung up her cleats, and because there are women filing cases too, WNBA, women's soccer. So when the career's ended, those are the danger cases because, again, statute of limitations, clock isn't ticking in California, and for a league to defend itself, I have to say, well, I tell them to stay out of California, but kind of hard to avoid the market. And frankly, there's a lot of talent here. A lot of kids are signing contracts in their parents' kitchen in a suburb of LA or San Francisco. So that part's hard to avoid.
Absolutely. Michael, before we let you go, because we're a sports and entertainment podcast, we're going to ask you a couple questions that are non-jurisdictional related. Tell us your favorite sports team of all time, that team that you bleed with, keeps you up at night when they lose. That's the question. Who's your favorite sports team?
Well, for college, I went to Berkeley for undergrad, and I still have season tickets to Berkeley football. I fly up whenever I can. I have a kid now, so it's been more difficult. So the football team hasn't been doing so good. They're under 500 for the last few years, so that's been hard to watch. The basketball team is 0-11, and that's hurting. I think Louisville finally won, so we're the only winless team. For the pros, I mean, unfortunately, some of my baseball clients are going to hate me, but I'm a Dodger fan, born and raised, so it kills me. The last playoffs really hurt, especially since it was San Diego that had won. The little brother wins one time.
Yeah, well, we here in Chicago took Cody Bellinger off your hands. I'm not sure if that's good news or bad. Last question on the podcast is your favorite movie of all time.
Ooh. So it's a tie between two movies. I'm a big Star Trek fan, so of course Star Trek II: Wrath of Khan. Yeah, I'm a nerd. The other one's it's a war movie, Patton, George C. Scott. I think thanks to my dad, I've seen every war movie and Western possible, black and white to present, and that one just ingrained in my head.
Good choices. Michael Pang from Allison, McLean, member of SERMA. Thank you so much for that really educational look at defending jurisdiction in athlete claims, and we'll see you again in the future. We'll see you all on the next SERMAPod.
Thanks, Rich. Have a good one.